An appeals court panel has ruled President Trump can maintain control over California's National Guard troops in Los Angeles amid anti-immigration enforcement protests, rejecting Governor Gavin Newsom's attempt to take back power. The three judges of the Ninth Circuit Court of Appeals ruled unanimously that Trump appeared to have acted within his authority when he took control of 4,000 troops under a law that has never been invoked without the consent of a state governor. The court said it disagreed with the White House's stance that the president's decision is completely insulated from judicial review, but argued the office of the president carries unusual weight in the matter. Newsom expressed disappointment in the ruling, while State Attorney General Rob Bonta said in a statement the case is far from over. Trump weighed in on social media, calling it a great decision for the country. Separately, a federal judge has blocked the Trump administration from forcing 20 Democratic-led states to cooperate with ICE in order to receive billions of dollars in transportation funding. In April, Transportation Secretary Sean Duffy notified states they could lose funding if they did not cooperate with immigration enforcement officers, sparking lawsuits from 20 states. But a chief district judge in Rhode Island ruled yesterday the department lacked authority to require states to cooperate to obtain the money, and that the White House provided no plausible connection to the purposes intended for the funding, which is to support highways and bridges and other projects. So, Sam Stein, your thoughts?
Well, obviously a big win for Trump in one case and a fairly substantial loss in another. And I guess the larger picture here is that if you just step back and you look at all the levers of government that Trump is using, all the resources he's putting through to put together this massive deportation regime, it's striking. Using the National Guard against the governor's will is an extraordinary use of power. Trying to leverage federal funds is remarkable. And I guess I'd ask Lisa Rubin, this latter case on the transportation funding, Lisa, is this just going to be limited to transportation funding, or does the federal judge's ruling have any applicability to other federal funds? In other words, can Trump turn around and say, okay, fine, I'll restrict some health care funds from a state then?
I think, Sam, you can take it as a warning sign, but one that doesn't necessarily have direct application to other agencies, especially since this is just a single decision of a district judge in Rhode Island with respect to that particular case before him involving Secretary Duffy and the fact that these states weren't as cooperative as the administration wants them to be with ICE enforcement. So if I were the administration, I'd take it as a little bit of a warning sign, but not necessarily a blanket disapproval for the larger strategy of trying to condition funding and other areas on immigration enforcement cooperation.
You know, Lisa, it seems there is a nexus in both of these cases, even though they're the decisions handed down by different courts. You had the three-judge panel saying the president had authority as it pertained to the National Guard, a good bit of authority, and the justification was to protect federal law enforcement officers and also to protect federal buildings. So there's that nexus there, and I suspect the Supreme Court will likely uphold that decision. On the other side of it, though, you have funding for roads, bridges, and airports being held up because of decisions states make regarding immigration and their relationship to ICE. Not that clear nexus there. Is that how we should look at these two cases?
Not necessarily, although I can understand why you're looking at it that way. I mean, Joe, one of the things that differentiates these two cases is that in the case of Trump's decision to federalize the National Guard, there was a statute that he called upon and invoked in order to do that in a June 7th presidential memorandum that then empowered Secretary Hegseth to call up the National Guard when he determined that through usual forces or regular forces, the president was unable to execute the laws of the United States. That is that particular provision of the statute that Trump was relying upon, not the part that says that you can call them up in the instance of a rebellion or an invasion or a danger of one of those two. So in that respect, that is somewhat of a victory, too, for Governor Newsom. You don't have this appeals court saying, oh, there's a rebellion or an invasion, and of course we should grant deference to that decision. But more globally, the bigger picture difference between the two is you've got a congressionally enacted statute, one that's been in place for decades, saying that the president can do this. In the instance involving the Secretary of Transportation, there was nothing that empowered Sean Duffy to make that determination. In fact, that was what the court sort of rested on, that you don't have this authority to take already appropriated funds in your context and condition it on something that Congress didn't say it was dependent on in the first place.
Well, and the other thing, you use the word globally, is that before we were talking about Iran, our focus was on Los Angeles and what was happening in the streets there. This decision, in essence, gives Trump the green light to use the National Guard in other states. And the administration has been hinting very publicly that they're going to go into New York City, Chicago, maybe some other states, all happen to be blue. What is the mood like, Elizabeth, that you sense from talking to lawmakers, state officials, about where this goes from here now that the president does have the legal green light to use the National Guard?
I can tell you that in New York City, if he deploys the National Guard in New York, it'll cause it's going to cause a giant outrage and create probably more violence than there would be anyway.
Isn't that what he wants?
Well, that's of course one of the working theories, that he wants to, create this all over the country and then, declare martial law. I mean, there's no sign that we're anywhere close to that. But that's one of the fears you hear from Democrats, And I also want to say, just talking about the Sean Duffy case, let's not forget what happened in Maine, where the Trump administration froze funding for a child nutrition program in Maine because Maine was allowing transgender youth to compete in sports, and that was stopped. But that's another example of again, the Trump administration trying to use anything in its powers to advance its policies.
So, Lisa, a question from David Ignatius in Washington. What are these two cases and the whole range of legal action that's going on now tell you about where we're heading in the showdown that's clearly ahead for the Supreme Court in testing the extent of the president's Article 2 powers broadly? We're heading toward a big case that will be, epical. What's your sense as these cases move forward about where we'll end up?
Well, it's interesting because, David, this particular case, the one involving Los Angeles and California, the Court of Appeals last night saying this does not involve the president's constitutional authority, because at the district court, when asked, the Department of Justice very clearly said, no, we're relying on this statute. And they were given every opportunity by the district court judge, Charles Breyer, to invoke a particular constitutional authority. They couldn't think of one. When they went to the Court of Appeals, they said, oh, now we're relying on the president's inherent Article 2 powers. But the court didn't buy that, and last night's decision limited him to the statute itself. And so there's a lot of good news in this opinion, in a way, for Gavin Newsom and Rob Bonta in terms of escalating this fight, because although the court is granting Trump what he wants, they're doing so in a way that leaves a bunch of open issues, including the continued vitality of this 1827 opinion that they say they had to rely upon in granting Trump this deference. But you're absolutely right. There's going to be a showdown over his constitutional authority and how broad the executive powers are. This is the unitary executive theory that has been advanced on Trump's behalf since the Bill Barr days, just trying to increasingly enlarge what belongs to the president and the president alone. That's going to be at some point at a head at the Supreme Court, and particularly if it arises in a foreign policy or a military context, there are many, Joe included, I think, who would say that the Supreme Court is likely to side with Trump.